DUIs and the statutory presumption. In a recent trial we did that we won, the prosecutor was telling the jury that since the breath test came back above 0.08, the jury was allowed to assume that my client's blood/breath was at least 0.08 when the officers first encountered her. That is not how the statutory presumption works. Statutory presumption is very simple. In order to make it a little bit easier for the state of Indiana, because it's not easy enough, the legislature said, hey, listen, if somebody gets pulled over at 7 o'clock and they blow a 0.08, 0.09, 0.10, 0.23 at 7:45, instead of making the state bring in a scientist/toxicologist every single trial, we're going to give the state a 3-hour window. And that 3-hour window says, hey, as long as the officer gets the blood or the breath within 3 hours of actual operation, then the jury can assume that the blood breath 45 minutes or up to 3 hours later was the same as when the officer first encountered the individual who was operating the vehicle. DUIs are already easy enough for the state, but this is like a little extra gift to make DUIs a little bit more easy and not require so much math. Because of the presumption, so many attorneys are like, well, nothing we can do for a DUI, you gotta plead guilty. That is wrong, and that's lazy attorney speak. Statutory presumption number 1 is permissive, meaning the judge will even tell this to a jury. The jury can accept or reject the presumption. They don't have to find the person guilty. Number 2, the statutory presumption only applies if the blood or breath sample is obtained within 3 hours of actual operation. Operation means being in full control of the vehicle. It doesn't mean being found asleep on the side of the road a couple hours later. It doesn't mean the person's inside their house and the officers stumble upon them. It doesn't mean a car is pulled over and the person is walking 25, 30 feet ahead of time. Because it's a criminal statute, it's precise, and the Court of Appeals and the Indiana Supreme Court hold them to it. Some attorneys say, no, Marc, the statute says 3 hours within probable cause. Well, those, again, lazy attorneys, because when you do a little bit of research, you find a case called Mordack. It's 3 hours of operation, not ideation of probable cause. There's a lot of fancy words what I'm saying, but the bottom line is the officer has to prove that you operated that car within 3 hours of the blood or breath. That's not as easy as it sounds, and that is something that's regularly attacked. So the presumption, it's hard, I'm not going to lie. It makes it easier for the state, harder for defendants, but don't ever think that it's game over because you got the blood or breath. There's still plenty of work to be done. If you have any questions about the statutory presumption, well, I love talking about DUI. I'll talk all day about it. Give us a call, 317-632-3642. And remember, always plead the fifth.